Morning. We've got quite a few bills, and we'll get to as many of them as we can, obviously. And the ones we don't make it to today, we'll obviously have more meetings. We're going to jump around a little bit because there's some people that need to present and get on to other committees. So I apologize for that. But we will start off with Senate Bill 2355. That's Senator Bart Williams' bill, and he has graciously joined us this morning to explain the bill. Senator, you're recognized.
Thank you, Mr. Chairman. I appreciate you having me to explain the bill. Bill is known as Walker's Law. I think as everyone's well aware, about a year and a half ago, we had a young teenager in Starkville that took his life because of sexual extortion. Since that event's happened, I think we've had some other tragic events in the state as well. We have done some research, and we have currently nothing on the books for sexual extortion. This law simply does that. It puts it in place. We create the offense of sexual extortion. We also create the offense of aggravated sexual extortion, and sexual extortion being a misdemeanor if it is committed by someone under the age of majority. I'll be glad to go through the bill in detail if you'd like, or answer any questions that someone has.
Yeah, if you will go through it and kind of tell us what it is for those of us who maybe are new to the committee and aren't familiar with the terms.
Okay, I'll do it as best I know how. Section 1's the title, of course. Section number 2 has our definitions in it. Section 3 refers to sexual extortion, the crime of sexual extortion, and the penalties therein related to that. Section 4 is aggravated sexual extortion, and the penalties that are related to that as well. Not to exceed 20 years is how it's listed. Section 5 talks about youth courts, and there again, if it's a minor, it's a misdemeanor, not a criminal act. The Section 6 talks about the fact that if this is committed in Mississippi, if a person's on a electronic device and it's committed in Mississippi, this law, wherever it originates, we can go after them. And the effective date is Section 7.
Give us a fact scenario, if you will. Like, talk us through what this actually is. What happened that led to the tragic death of this?
I'll go through the situation with the details. I know the young man that tragically lost his life, and his father has been a big proponent of trying to protect our underage children. On the internet, we've done a great job at delivering fiber and things throughout the state. With that, I think comes hazards of the internet, and I think we've got the responsibility of coming alongside and trying to legislate where we can to protect our children. This young man got online on a social media site and ended up having a conversation with what he thought was another young lady, probably similar to his age. Through that process, some explicit things were exchanged, and this was about a 3-hour period from the time this young man started till the time it ended. And through that 3-hour period, there were a lot of pressure put on him to extort money out of him. I know that somewhere through that, he made the comment that I'm going to kill myself. The people on the other end said, "You're dead already." At the conclusion of that 3 hours, this young man ended up taking his life. So with this exhortation, we've got, a penalty there, something that's in black and white, that if someone's going to try to commit this act, we're going to be aggressive, we're going to come after them, and we're going to prosecute.
Essentially, someone is tricked into sending a compromising photograph of themselves, and then they find out, lo and behold, this was not really somebody that was, interested in me in that way, and then start sending emails saying, if you don't send me $10,000, I'm going to release this to the public or to your parents or to your employer, those types of things, right?
That is exactly correct. And as I understand the way these things happen, you got an underage child that's very influenceable, and through their conversation, 3 hours is a long time. They're able to kind of find out where the weak points are and where they can really touch the pressure points. And with that, they say, we're going to share this at your school. We're going to do it, whatever they think will get a reaction to get $1. I mean, at the end of the day, it's extortion is what it is, what these people are trying to do. And these young people, this is not just for minors that's reflected in here, but these people get in a very vulnerable moment as reflected by what we've seen happen in our society.
Okay. Questions for Senator Williams? Motion's title switches do pass. All in favor say aye. Any opposed, nay. The ayes have it.
Thank you, Mr. Chairman. Thank you, committee, for having me.
Sure. All right, Senator Horn, did I see you walk in? Yes, there's Senator Horn, Chairman Horn. We're going to go back up to Senate Bill 2016, and you're recognized, sir, if you'll explain this bill to us.
Increase fines for illegal dumping that is going on in our state. know that, I don't have to tell anybody in this committee that illegal dumping is becoming a major problem, both in rural communities, in urban areas, along parts of the interstate, and the city of Jackson, for example, is not unusual.
Use your microphone a little bit. I
I'm
think the
sorry.
people online can't hear you.
Sorry, Mr. Chairman. In the city of Jackson, for example, there are plenty of instances where not only are you seeing litter on the interstate, you're actually seeing illegal dumping of commodes and living room furniture and all sorts of stuff along the interstate highways. But the pristine countryside in some of our rural areas is being just torn asunder by the fact that this is becoming a greater problem. People are doing it with impunity. And so the idea of this bill is to essentially take the misdemeanor fines from from $250 up to $500, I believe. Yeah, $500, and that it would not exceed more than $1,500 for a misdemeanor fine of illegal dumping. That $1,500, I think, went up from $750. As it relates to the felony charges, it goes from $1,000 for a fine of more than 15 pounds or not more than 100 cubic feet of volume, and then it raises it from $500 to $1,000 for that, and then for allegations where there's more than 500 pounds, the fine goes up to $75,000, I think from $50,000. That's essentially what the bill does, Mr. Chairman. I had initially wanted to offer an amendment, but in reviewing the bill, that issue is already being addressed in the existing law. So that would be my explanation of the bill.
So that was a community service requirement to, if you could identify the dumper, that they could be required to come and help clean up.
That is correct, and that's already addressed in the bill.
Okay. I'm a big supporter of anything we do to help clean up the roadways in the cities and, like you said, the counties. I rarely drive anywhere in the state. I'm fortunate to say that you don't see litter and trash all along the highways and byways. So I applaud you for bringing this forward. Any questions for Senator Horn? Senator Simmons.
Thank you so much, Mr. Chairman. So the penalty as it relates to the misdemeanor portion of it and the felony portion, we are not increasing the actual penalty regarding the imprisonment, are we?
No,
Okay, just only increasing the fine, Senator Horn?
correct.
Thank you. Thank you, Mr. Chairman.
Any others? Not, then for a motion? Motion's title speech do pass. All in favor say aye.
Aye.
Any opposed, nay. The ayes have it. All right, thank you, Chairman Horn. We appreciate your time.
Thank you, Mr. Chairman.
Yes, sir. All right, Senator Johnson has joined us as well, and he has Senate Bill 2288, and I believe there's a committee substitute available on that one as well. So, Senator Johnson.
Thank you, Chairman. Bill 2288, fine. Videos and audio, especially using artificial intelligence, in creating a video, text, image, or audio of someone doing or saying something that they did not do. And apparently this is a growing problem in many ways, from explicit videos to advertising to a misrepresentation of what a political leader may say. And so this bill would put criminal penalties with offenses of doing that without the person's consent. And there are a few exceptions in the last section. And the penalties range from $2,500 and or 1 year in jail up to $5,000 and 5 years in jail. And that's an explanation of the bill.
And so is this essentially like the Taylor Swift situation? I think a lot of people are familiar with, where you take somebody else who's doing something explicit and you take her face and place it on the face of the actual person doing it to make it look like she is doing something that she's actually not doing at all to either harm her reputation or for whatever reason. Is that what this is talking about?
Yeah, so that, I was not aware until recently of the Taylor Swift incident. I saw this in a Wall Street Journal article from last summer. But I think that that's one way, but with AI, you can also just generate a new video or image without using an existing that you're cropping a face or whatnot with. So, so yes, it would include both of those.
All right, questions by committee members?
Just a quick question. Is there a harm requirement in the bill? Like, does it require that the person whose image or likeness is being used is actually harmed in some type of a way?
Yes, it does. And I say this from a non-attorney. Let me answer this the way I think of it. And yep, just one
Want me
second.
the way you are. Oh, I think 59 maybe.
You found it? Yes, that's it. Does that answer your question?
Yes, I guess, I mean, here, without having been able to like read completely through the bill, there's an intent requirement, but not like actual harm. So I guess you would have to determine if the person actually intended to harm them, but there's no mechanism for whether the person was actually harmed. And I don't know what effect that has, but I would like for it to be like the person had to actually be harmed in order for someone to be criminally punished. But that's
So let me ask you, just so that I understand what you're saying. If someone were to take a person's face and then make a video and show it to others that person didn't know, that wouldn't be a crime?
yes, it could be if that person's reputation harm, even if they didn't know. If I did that and say you had a job interview and didn't get the job and didn't understand why, that's still harm whether you saw it or knew or not. But I guess this is specifically for if they use it in a sexual context or just any context.
Well, I think it's any context is the way the bill reads, because it could be that XYZ company is doing an advertisement with your face, audio, or voice that you did not actually do and don't consent to.
Yeah, let me look over this. Thank you.
So in a follow-up, Senator Hickman question, I think you raise a good point, but wouldn't you almost create a separate class of citizenry if you require that someone's past reputation be such that by showing this type of situation, that person's harmed? So in other words, if you are already engaging in these types of behaviors and now someone is showing pictures of you engaging in this type of behavior, that's not harmful to you because that's your normal mode of conduct?
Ask that one more time.
Based on your question, it seems like you're saying there must be harm to the individual who is depicted in said video. Well, if you try to argue that, well, he's already a very person of suspect background and character who engages in these activities routinely, then showing him engaging in yet another form of activity may not be harmful to him because his behavior is such that, that's what people expect of him. Whereas if you take somebody else who's not been past engaged in those types of behavior, they would then benefit from the statute.
And the only reason I ask these questions because in general First Amendment law, like when you're looking at name, image, and likeness, and all of these general civil things, there's a requirement that there has to be actual harm to the person who you're looking at in most cases. And that's the only reason I ask is, is there actual harm? But I also think it's more difficult to prove intent to harm. I mean, actual harm is easy to prove, like you can prove a pecuniary interest or whatever. So I think it makes the law more easy to prosecute or whatever if there's, if the standard is like actual harm, you can easily show that.
I hear your question. I'm certainly not trying to be argumentative, but I think what you're getting at is you're trying to make sure that people are treated equally, right? And so the idea would be you must show some sort of harm. I just wonder if that's the standard, though. Some people may not can show harm, you know, versus other people who are a previously chaste character, as the statute so antiquatedly suggests sometimes, could show harm, whereas somebody else couldn't show harm.
Well, I mean, I'll just take some time to read through it. This is, of course, the first of my seeing it. Let me
Sure.
just get a grip on it. That's
Good
just
question.
some things that stood out to me in the initial read through.
Gotcha. Other question? Questions? Okay. Senator Sparks.
Thank you, Mr. Chairman. In the generation of this, I mean, we obviously watch things all the time that are parodies. Do we have any consideration for that? Because obviously they make fun of public figures on a regular basis. In a parody manifestation, how do you differentiate between artificial intelligence to make it appear to be someone and somebody dressing up like somebody?
I think that's a great point. But when I think of parody, I think of like Saturday Night Live, and it's very obvious what they are doing with that. But if you create something that is not obvious that it's a parody, and I think this is what this does, because you're actually using that person's voice or face, representing that that's them doing or saying those things. So I view it differently. Again, I'm not an attorney, so you all would have much more insight. But you understand what my intent is.
Yes.
I'm happy to improve the bill in any way.
Thank you. Because I think the concern is that that's my actual statement. That's me saying it. It's not someone mocking me.
That's correct. Yes.
Thank you.
Questions? All right. Any others? Senator Simmons? The nation's title sufficient to pass. All in favor say aye. Any opposed, nay. Oh, committee sub. Yeah, thank you. Committee sub. All in favor say aye. Aye. All opposed, nay. The ayes have it. Good discussion. All right. We were joined by, who else came in? All right, Senator Thompson is here, and Senator Dillon is here. All right, Senator Thompson, we have Senate Bill 2196.
Thank you, Mr. Chairman. Senate Bill 2196 is a revision to the Mississippi Terroristic Threats Act. If you look in lines 32 to 37, it basically adds a 5-year enhancer to terroristic threats made against an airport. We've all seen the videos of air travel recently of people freaking out in planes and around and in airports. If someone makes a terroristic threat against an airport, the consequences of that are pretty far reaching. You wind up disturbing flights get canceled, delayed, the airport gets shut down, et cetera, et cetera. So the proposal here is that the consequences for making such a threat and causing such a disturbance, the penalties should fit the consequences of that threat. This is a bill that was brought to us by the Jackson Airport originally. I've checked with my folks at the Gulfport Airport, and they had a recent incident back in December that led to the airport being shut down. People's bags were delayed, flights were delayed, on and on. So this is something that apparently actually happens. And this is a bill to try to enhance the penalties, the consequences of those threats. Happy to answer any questions.
All right, questions for Senator Thompson? Not for a motion? Yeah, I'm sorry.
We could share the mic here. So what you're doing is you've already got the language in it that says it's punishable by not more than 10 years. You're putting a minimum of 5 years on it.
It's 5 years in addition to the 10,
So you're adding an additional 10.
additional 5.
The additional 5 on top of a discretionary sentence of up to 10.
Correct.
So was there any consideration in just maybe extending it from minimum, maximum range in there? Because I'd hate to get into a situation where we have a mental health problem and we're saying, you know, sorry, I understand you may have had a breakdown today and it's stupid. So we're gonna send you to jail for 5 years instead of get you your treatment. So minimum, maximum, I'd rather see that where we have the discretion for the judge to hear that. Instead of having you're going to jail for 5 years because you have shall language.
Well, so what you're
I'm just asking why we went that route instead of even having consideration of minimum, maximum, you know, 3 to 15 years, minimum, maximum language in there instead of the 5 years on top of your other sentence.
on top of the others. What would be the difference? And I'm asking because I don't know. What would be the difference?
This says not more than 10, and yours says shall be punished by 5 years, convicted under this. So basically, you're saying you could get 2 years on the top, and then you've got to add 5 years on top of it, so you got a total of 7, right? So your only discretion would be in the first up to 10 years.
And then
And even if they had 30 days in the first 10 years, they've got to have 5 years later.
Correct.
So I guess that was mine. I feel like we've just gone a long way around getting a minimum, maximum range in there.
What would be the proposed minimum max you would have? Would it be a revision to A?
I mean, you know, you can mirror the language in there. So do you have a recommendation? What was your, go ahead, Tom.
I'd make a motion to,
Is he recognized?
You're recognized. Go ahead.
got in the middle.
Never did. Yeah.
As it is in the prior section, put up to 5 years, or not more than 5 years. You can still have your 10 years plus 5.
I'm not sure I understand.
Well, so your language in 3A says, for not more than 10 years, I would have part B. $15 years. They wanted to.
Would you need to have any would you need to have any language added to A to make it clear that the part in B is an enhancer to A? That may be a question for council.
Probably a good point.
I think that language on 36 and 37 might cover it.
I was asking if his proposed, Senator Super's proposed.
I guess my recommendation may be that you just go ahead and put a 5 to 15 minimum, maximum, and leave the discretion in the center for them. For the judge to go up to 15, but got to have the 5 years if you're gonna have the shall language.
Regardless of if it's an airport or not.
And I would rather see the minimum, maximum in there because you're not leaving any discretion for a judge in there other than saying you have discretion in the first 10 years. But we're gonna tell you, you're going to sentence for 5 years after.
That'd be a friendly amendment.
So where would we put that in? Is there any other discussion on that?
If you'll restate your amendment, I don't think we heard it over here.
Well, I haven't made a motion yet. We're just trying to work out, the recommendation would be, before we even do a motion and discussion, Mr. Chairman, would be we just do a minimum, maximum in there. You know, minimum. Whatever you're gonna do in there.
But you still, in that scenario, you're still not requiring anything. I mean, if it's all discretionary, the judge can still say, yeah, 6 months.
Well, and that's why I did suggest a minimum,
What is the minimum in that scenario?
and that's something that's gotta be determined.
Okay.
He's wanting 5 year minimum, pretty much,
For airport.
for airport.
Right.
which is how it works out essentially in what you've got here. It's just, I was wondering,
Yeah.
do you immediately go and put the 5 years in there for an airport threat when you're not giving any discretion for a mental health problem or anything else? You've got shall language that says shall be 5 years. So if you have something else going on, an extenuating circumstance, you have no discretion for a judge to say, we're gonna send you this route instead.
But
You've got
in,
5
so
years.
in my questions in the mental health scenario, what's the difference between what's in current law? In current law, you're saying there's not more than 10 means if the judge finds extenuating circumstances.
Could give them 6 months to put them to treatment or whatever it may be. Or give the 10. From my understanding, basically, you're saying the judges are not giving time, and you're trying to strengthen this further by requiring 5 years at an airport, period.
But I'm happy to work with you if there's a range.
Let's look at that further. I mean, I have no problem with looking at a minimum maximum range. And that's what I'm saying, but I do think there needs to be some discretion somewhere in there instead of just saying, you got 5 years, period. Sure. So, anyway, thank you for considering that.
Yeah.
Okay, so what's before us currently is Senator Suber's amendment, because he was recognized for an amendment. Okay, okay. Would y'all like to lay this one on the table so y'all can continue discussing?
I think we,
I mean, we're gonna meet more. This is not our last meeting. Senator England?
Thank you, Mr. Chairman. I have a question for Senator Thompson. Senator Thompson, we've had some thoughts here about your bill. If we move title sufficient to pass this morning, would you be open for a floor amendment if we're able to get it to that point? That way we can move it through committee today?
yes.
Well, then would you like to add a reverse repealer to make sure that it doesn't go?
Yeah, I think that'd be prudent.
I can make that motion as a member of Jud B committee.
All right.
I move that, my motion is that we add a reverse repealer to the bill.
Okay, any questions? Heard the motion, all in favor say aye.
Aye.
Any opposed, nay. The ayes have it. All right,
Thank you, Mr. Chairman. Thank you, members of the committee.
all right,
I'd move title sufficient to pass as amended.
all right, you're recognized for that. All in favor say aye. Any opposed, nay. The ayes have it. All right, good questions.
Thank you, Mr. Chairman. Thank you.
Y'all continue working if you would, and let us know. Before we take it up on the floor, in case we need to do a floor amendment, we can certainly do that. All right, we're gonna recognize Senator Delano for the last bill on the list is 2627. Senator Delano?
Thank you, Mr. Chairman. There is an amendment that our committee sub that we would need to make on this particular bill. Ethan, you have that? Okay, great. Mr. Chairman, the committee sub that's on the last page of the packet is intended to provide intended to provide state code that mirrors some of the federal code regarding the modifications of a semi-automatic firearm into a machine gun. This is necessary because of some of the instances that we've seen, what's commonly called on the street a Glock switch, which is a device that's actually printed from a 3D printer. And we've actually on the coast have found that some of these are being printed from our high school 3D printers. It's crazy. But these devices are used to modify an otherwise normal semi-automatic firearm into a machine gun. The language in the proposed committee sub has added some things that came from the NRA that modified the definitions of a machine gun in section 1, subsection 1I. And anyway, that is the language that was preferred by the NRA. It does have, like I said, it mirrors what is in our federal code, and it provides for any person convicted of a first offense shall be guilty of a felony and shall be sentenced to imprisonment for the term not more than 10 years and not fined for more than $3,000 or both. Second offense would be not more than 15 years and fine not more than $5,000. And that's an explanation of the bill, and I'll yield for questions.
So are there any instances where doing this modification would be legal, or is it anytime you would find one of these that it would automatically be illegal?
Thank you, sir, for that question. In section 1, number 1, it talks about, it says any person who manufactures, possesses, or uses a machine gun conversion device and who is not otherwise authorized by federal law to manufacture, possess, or use machine gun conversion devices shall be guilty of this felony. So yes, sir, if you do have a federal license to hold or to possess one of these devices, then you would be excluded from this. And that's another part of the component that the NRA and other gun advocates across the state wanted to make sure that we did not conflict with their licenses through federal registrations.
In other words, if you're a gun enthusiast and you're not a criminal, obviously committing a crime, and you just want to do this because you like guns or whatever, there is a means whereby you can go through the procedures on the federal level to get permission to do this?
That's correct. And we are not modifying that in any way, shape, form, or fashion.
Thank you, Mr. Chairman. And I think Senator Delano started off his explanation by saying we're trying to mirror the federal law for the first offense and the second offense. Are they respectfully 10 and 15 years under the federal law? Do you know?
I can't speak to what the federal law exactly is. What we're doing is placing a state code over and having it mirror what the federal code is. But I'm not going to attest to you that the penalties are exactly the same.
Thank you, Senator. Thank you, Mr. Chair.
Barnett?
Discussion in regards to the fines, both the sentencing and the dollar amount on both of those first and second offenses. And the reason I ask is because we know that this is pretty serious. And most of the time, those people that got involved in this are large-scale drug dealers as well. And so I just want to make sure if we're going to punish, then we need to make sure that we're making a statement in regards to these people with these automatic guns that they're using. So I would like to see a more penalty on the sentencing and the dollar amount. $3,000 and $5,000 to me is, I mean, we're not making a statement. Thank you.
I'm certainly up in that, but I'll leave it to the discretion of the chair.
Would you like to make an amendment to that effect, Senator Barnett?
Either here or we could talk about it, and if you agree that we could talk about it and take the amendment up on the floor.
Senator Simmons for a question.
Yep. Thank you, Mr. Chairman. I'm not actually opposed to what Senator Barnett is suggesting, but if we can just look at what the federal law is and try to be as close to the federal law as possible, and because I mean, we put in 10 years for first offense, 15 years for second offense, and there still is a gray area on whether or not the person has the necessary requirement on the federal law to even be modifying it. And I don't want to be representing the person who was just modifying it, was not engaged in a crime, and now I'm representing them and they looking at 10 years and I got to go through a whole proceeding just to prove that he or she had all the necessary requirements on the federal law to do what he or she was doing. So, I mean, if it's okay, Mr. Chairman, can we just look
Certainly.
to see what the federal law?
Looked at those yet? Because I think a quick Google search will tell you it's about $250,000 is the federal fine.
And what's the penalty?
That you want to go that high?
And then what's the penalty? He wants to go up on it. So, but yeah, so the fine is 3,000, yeah, 5,000 respectively. Yeah, that's low. But I was just talking about the time as well, 10 and 15. Thank you, Mr. Chairman.
Barnett?
Thank you, Mr. Chairman. And Senator Simmons, I respect that, but at the same time, you know, around this place, I noticed that we pass laws and things depending on what happens to us or someone that we know, and that's after the fact. I'm just trying to pass some laws to do something before the fact, that we have to come back because someone that we know, a loved one, a friend, or someone else has been affected by someone else manufacturing this and then it's used in a way that it shouldn't be used. And so I think if we're going to attack this, like this, I think this is the best way, so. But again, I'm open for discussions on this. Thank you.
Has a question.
Thank you, Mr. Chairman. Senator, I know we're using the term machine gun. I want to make sure it's clear. This is making a weapon fully automatic.
Absolutely.
Is there any scenario where a non-military person is allowed legally to have a fully automatic weapon in this country?
I believe there are federal permits that can be acquired that would allow for the possession, modification, and manufacturing of those types of devices.
So that's the exception you're referring to, that if
Yes.
someone had a weapon
Yes,
that
sir.
in fact had been modified, it would be a defense to it to show that that gun actually had been properly approved for that process?
Yes, sir. There is a provision for a law-abiding citizen to be able to possess and own and manufacture these types of devices.
I just want to make sure, because there's still a lot of people in this country that think AR stands for assault rifle. So, thank you.
Thank you.
Senator Suber.
Thank you, Mr. Chairman. Senator Delano, have you thought about adding any language for like a forfeiture of the weapon? I don't know if that would automatically, our forfeiture laws we have now, if it would apply to this, but you think it would help if we added something to reference like forfeiting the gun?
Well, that is not included because in most cases, if it's, I think there's some existing law that may cover that. I tried my best not to put any language in that dealt with the government seizing any type of a weapon whatsoever. But I do believe that the device itself would be something that would be subject to, which is the switch, the actual piece that's been modified, that could be taken because it's illegal to possess that. But that is something that I'm going to let the committee and/or process work through that.
All right, thank you.
Senator Simmons, you have a question?
I think it's a good bill. I just think, I mean, is this not a gun control bill?
In the eye of the beholder, I'm sure. All right, any other questions? Senator Hickman.
Just a quick question. As this is written, let's say we have someone and they're caught and they manufacture. Like the second one, it says second or subsequent offense. So I'm guessing the second one could be simultaneous at the same time.
Senator Delano.
Mr. Chairman, I can't speak to how that would be interpreted by the case law, and I would defer to legal for an explanation.
And I'll just add that my asking of that question is not in opposition. It's just that I feel like there are mechanisms where if a judge feels like someone or a prosecutor feels like someone is a real issue, they have the mechanism in front of them to, increase or do whatever they want to. I think this bill leads them to that.
I think I agree with your interpretation as well, Senator Hickman. All right. Other questions? All good ones.
Mr. Chairman, I just want to make sure that I point out that this bill has been vetted by the NRA to make sure that it comports with the gun enthusiasts for our state and does not infringe in any way for law-abiding citizens. This is intended to remove very deadly, very lethal weapons that unfortunately have been used within our state. And we had a law enforcement officer in George County that was killed using one of these devices. And this needs to be eradicated from our state any way possible. This is a small step in that effort.
In light of that, was it you or someone else asked me if we could name this bill for the deceased law enforcement officer that was?
I understand the reason for the confusion, but that was Senator DeBar.
DeBar had asked about that, yes. All right, well, in light of Senator DeBar's question, I would move that we amend the committee substitute to name it in favor of the deceased law enforcement officer from George County, I believe it was, that Senator Barr wanted this name for.
Mr. Chairman, in discussions with Senator DeBar on this yesterday, he asked if we could do that on the Senate floor. He would like to have that opportunity.
Duly noted. All right, any other questions? All right, Senator Simmons.
Just last question, Mr. Chairman, and based upon Senator Delano saying that it's been vetted by the NRA, my question is the fine, 3,000 and 5,000 respectively for the first and second offense. They don't want that to be touched, or would they want that to be increased? Because I mean, those fines are low anywhere in our criminal statute.
Yeah, I would agree with you, sir. I don't have a comment back regarding the actual fine amount. I think that's really left up to the state. We wanted to make sure that the definitions that were used in this statute did not conflict with any federal law or any gun owners' rights, law-abiding gun owners' rights.
So I have an amendment, Mr. Chairman.
Recognized.
So on line 23, my amendment will be changed 3,000 to 10,000, and on line 27, my amendment would be to change 5,000 to 20,000.
I concur.
All right, any questions on the amendment for Senator Simmons? Anybody? All right, all in favor say aye. Aye. Opposed, nay. Okay, the ayes have it. Any other questions? If not, for a motion? Motion is House 52 pass committee sub. All in favor say aye. Any opposed, nay. The ayes have it. All right, thank you, Senator Delano. We appreciate that. All right, Senator McClendon has joined us. Thank you. He has two bills on the agenda. So we'll start with Senate Bill 2135 dealing with shoplifting. And if you'll use the microphone, they tell us the people watching online can't hear it without that.
Thank you, Mr. Chairman. Thank you, committee's members, for allowing me to be here. Senate Bill 2135. It's to delete the requirement that a court finds substantial and compelling reasons why the offender cannot be safely and effectively supervised. It's not amenable to community-based treatment.
Okay, we can't hear you. Sorry. You can move it up a little bit closer there.
We've got to get y'all
There you
better
go.
microphones so we have
Try again.
Basically, Senate Bill 2135. To delete the requirement that a court finds substantial and compelling reasons why the offender cannot be safely and effectively supervised in the community. Is not amenable to community-based treatment or poses a significant risk to public safety before imposing a penalty or imprisonment for the crime of shoplifting and for related purposes. The reason for this bill is I'm bringing news from North Mississippi. I don't know how it is all over the rest of the state because I don't live there, but I do live in DeSoto County. And we are being inundated by shoplifters. It's an epidemic proportion. All 5 of our mayors are pleading that we raise the penalty, that they will be put in jail. And that's basically what this bill does.
So in the bill we took up last year regarding this, I believe we required the judges to make a finding on the record as to all these things you were just going over in order to impose the sentence. So I'm just trying to understand the practical effect of your bill would be to remove the requirement the judge make those findings on the record. Is that right?
Correct.
Okay. So, and your purpose in doing that is what again?
The purpose is Target, Home Depot, all these larger chains have their attorneys. They get shoplifted every single day. And the criminals know they're not going to be prosecuted. And they will not be put in jail. So basically, they've just quit doing it. They've letting people come in and shoplift. Now it's bleeding to the mom and pops. And we're asking that we do not put people in jail. If they commit a crime, put them in jail.
He couldn't hear that part. Senator Simmons, would you restate that last piece?
What piece?
The part about what your mayors are asking.
They're asking that criminals be put in jail.
Okay, Senator Sparks has a question.
Thank you, Mr. Chairman. Senator McClendon, I just want to make sure that it's clear what we're doing. We're removing the fact that a judge make a finding if they're going to jail them to show that the person can't be managed in some other way in the public. Is that what you're trying to remove, is that if the judge sentences someone to jail, because on the first offense, there's no mandatory jail. It's up to 6 months. So even if we remove this finding requirement, someone still may not go to jail. And on a second offense, the minimum is 48 hours, which is, I think, what we did on this end. It's a mandatory minimum. But once again, you want to remove that, just the finding, correct? You're not adding to the sentence. You're not reducing the sentence. You're just removing that a judge has to make a finding to put them in jail, correct?
You're making it $1,000 punished by imprisonment in county jail.
But you're not changing any of the penalties.
No.
All right, I just want to make sure everybody was clear on that. Thank you.
Great question. Senator Wiggins?
Well, to that point, but you stated that we wanted to increase the penalties, but the bill that's before us is not doing any of that. So what you said the bill does versus what is before us is different.
Pardon me, this is my fourth bill. We, again, would like people to go to jail, the committee.
Okay, so that brings up my next question, which is if it is, well, I guess to Senator Sparks's question, there is nothing in the law right now preventing them from going to jail.
And what,
Okay, if the judge finds under the language that you've removed that all the dynamics there, that doesn't apply, the judge can send them to jail right now.
why is that in the bill, that language?
I don't know. That's what current law is, but that's what current law is. But
And that's what
I
we
guess
want to.
what I want to be clear is, as Senator Sparks pointed out, the language that's being removed in no way prevents under current law the judges from putting somebody in jail right now.
The issue is that the chain retailers feel that there's no substance in the bill for them to try to prosecute a shop.
Well, that's wrong because in that sense, that's wrong because the penalty is $1,000, as you said, and 6 months in jail, which can still be done right now. So I think the question, it may be, and please answer this to what Senator Sparks is saying, was asking is, this bill is not changing current law. It's more of a prosecution discretion issue than it is a law issue.
So if the judge doesn't make a finding, then they can't be sentenced.
Well, no, I think the other way, under current law as it's written, if I understand, is if the judge finds on the record that those things apply, then they don't have to send them to jail.
So we're being light on crime. Is that what we're doing?
Senator
The
Simmons.
question was, are we being light on crime?
Thank you, Mr.
What-
I'm sorry.
Go ahead. Oh, I'm sorry.
Senator Simmons, you're recognized.
Thank you, Mr. Chairman. And I'm certainly empathetic to Senator McClendon and you getting calls from the mayors. I mean, we get those calls too. But I agree with Chairman Wiggins that this is more so a prosecutor discretion type issue and the actual judge in those respective areas. I know every year, I'm quite sure you all go through the same thing. In January, my councils and my mayors, they go through a process of evaluating the judges and making a decision on whether or not the judge is doing what he or she's supposed to do based off the feedback they're getting from the community. And if a judge is not being responsive to the retailers in that area and sending people to jail, then there's a process in all of our districts to respond to those judges and prosecutors in those areas. But I can tell you in my area, Senator McClendon, people are going to jail for shoplifting. And they are spending time in jail for shoplifting according to the existing law.
I have a question, which may help clarify. If the folks in your area are saying that because the judges have this extra step they have to go through in order to put someone away, and they're not doing that just because of the extra hassle of having a hearing and making the rulings on the record, is that what they're suggesting to you is the holdup in getting these people prosecuted and convicted? Is just that extra step the judge has to go to make these findings, and so by removing that step, it may make it easier to go ahead and lock them up? Is that what they're saying? Okay. That may be part of the explanation. I'm not sure. I haven't spoken with the mayors, but I understand what the committee members are saying, which is you're really not changing the penalties under your bill. You're just removing a requirement that a judge has to have a
Why do
hearing.
we have an extra step? We're trying to cut red tape.
Okay. So I think Senator McClendon is saying that because of that extra step that we're requiring in the law, it's making it more difficult to get the prosecutions of these people, right? Senator Wiggins.
What question to that, Mr. Chairman? So to that point, the maximum penalty on a first is 6 months. If it's as bad as you say, which I believe it, so every one of them gets sentenced to 6 months in jail. Is there enough jail space? Let's say it's 1,000. Is there enough jail space for 1,000 shoplifters to spend 6 months in the Hernando jail or whatever?
We're willing to take that. We're willing to add on. We're willing to,
But that's not my question. Is there enough space to house 1,000 shoplifters at 6 months on a 6-month sentence max?
we'll be willing to build them.
Okay, what about Issaquena County? What about Jackson County? What about Harrison County?
Well, do we want to live in a lawless society?
As has been pointed out, nothing in here is changing the law. And in fact, the judges can go ahead and sentence them to 6 months in jail. All they have to do is find this step. About the language that's being deleted.
If a person commits a crime, should they not?
Well, yes, they should go to jail, but there's also things called probation, which this is what the language you're deleting is removing is probation stuff, which is a different story. So you're saying you want them to go to jail and not be eligible for probation?
We won't target in them to go on and prosecute.
But Senator McClendon, with all due respect, the law as is currently is not preventing them from prosecuting or sentencing them to jail right now.
But they go and they spend all their money for a judge to say, okay, we're gonna put you on probation.
But they don't have to. All the language is doing is saying that they just have to make a finding. There's a difference between a finding and a sentence. In this committee, we deal with that all the time.
All right, Senator Hickman had a question, I believe.
And this is for you, Mr. Chair, or Senator McClendon. In the system that we're talking about, specifically to why this bill was brought, you're talking about the municipalities that are located in DeSoto County, which is where most of these big retailers are located, correct? And they're going to municipal court, right? Yes. And so the mayors who are talking to you, don't they appoint both the prosecutor and the judges who they say are not doing their job?
They do, but the way that this reads now, they can send them there all they want, but it's a hand slap. They want them to go to jail. They want them to stop shoplifting.
But the judges they appoint, they could clearly just go through the step that they're supposed to go through, and the prosecutor could make sure this happen. I mean, I don't think anything as the law is written keeps them from doing exactly what you want to do, except you're telling us that the judge and the prosecutor, who the mayors who are talking to you appointed, don't want to go through the extra step.
I don't know about that. All I know is we've got people shoplifting, and they're not going to jail. And as the law reads, they don't go to jail.
Senator Simmons has a question.
I just want to just clarify one thing, Mr. Chairman, and Senator McClendon, it's not an extra step. So basically, once the person is arrested and charged with the crime, he or she is brought to court. At that court proceeding where the judge imposes the sentence is when,
If they're found guilty.
I'm just saying, but at that same proceeding where that person has an opportunity to have a hearing on the crime that they've been charged with, shoplifting, the judge will, at that same hearing, do what we wrote in the law last year, which is actually put forth those reasons that you are proposing to take out. So I'm saying it's not an additional step or additional hearing. At the hearing where the person could be sent to jail, it's the same hearing that the judge will actually put on the record those findings. So it's not an additional step.
Senator Barry had a question.
It's more of maybe a suggestion than a question, and I appreciate what you're trying to do, and I like being tough on crime, and you know, the law degree I received by attending my brother's law school graduation is not sufficient enough to make some valid arguments here this morning, but would you be willing to maybe lay this down and come back and let's work on it, revisit it at a later time?
I will be, and I'll bring all 5 of my mayors up here as well and let them answer the question about their judges. And I'll try to get maybe store managers from Target and whatnot to be here if you can give me a time and a date, because they have busy schedules just as we do. But it is an epidemic, and I thank you for bringing this bill up, but we do have some issues with this.
For sure.
And if it's something that needs to be talked about at a judges convention or lawyer convention or whatever y'all do on the coast, just
So many things on the case. All right, Senator.
thank
England,
you
you're
for
recognized
consideration.
For a motion.
You do a lot.
Thank you.
So many things. All right, Senator England.
Yeah, thank you, Mr. Chairman. I think we've had good discussion, and I think we understand what Senator McClendon is trying to do, and we just need to maybe work on the bill. My motion would be to table subject call of the chair.
Heard the motion, all in favor, say aye.
Superseding motion.
Uh-oh, Senator
Motion to
Wiggins.
table.
Okay, so the motion table does take precedent. Yes, which is a killing motion. So would you like to speak to that, Senator Wiggins?
Well, point of procedural, is it killing because there's still the deadline? Yeah, so I'll speak on the motion. We've heard the discussion in here. I understand what they're trying to do, but we know DeSoto County, sorry, they have an issue, but this is a statewide bill. As I pointed out, there's 80 other counties and municipalities that, as far as I know, haven't asked for this bill. My guess is there's also, if we need to do it, there's other code sections available that will allow Senator McClendon to get this in order and we could put it somewhere else. But I think this bill as is, should I quote Harry Brown and say, when you see a snake, kill it? So my motion is that we table this bill.
All right, Senator Sparks would like to speak to the motion.
Yes, I'm for striking the language. I don't think the language should be in here. The issue, Senator, is if the mayors of DeSoto County have something to say, they can put it in writing to this committee, will be fine. But the judges clearly can sentence to the maximum already in the law. The only thing this would do by striking this would mandate that a second offense would be 48 hours. So I don't like the language. Don't know where it came from. Don't know if it came in on conference weekend. But I remember going through this process last year and talking about it. A second offense shoplifter, I have no problem with them spending 48 hours in jail. But I do have a concern, whomever is advising, that the law doesn't allow the judge to sentence, or that some big box retailer is tore up about prosecution. Because the articles I read is that they're not prosecuting. They're not detaining. They're not apprehending. Now, the mom and pops, it's a different issue. But I don't think we should table it. But I do think we need to get our house in order before we bring it back up.
With that, Mr. Chairman, I concur. but I withdraw my motion and, so that leaves motion to table.
All right, so the current motion then, Senator England's motion is table subject to call, and we do need to get downstairs. So all in favor of that, say aye.
Aye.
Opposed, nay. The ayes have it. Motion to rise and report. I'll call you. Thank you.
No, but. Oh, debate.